Hello, everyone. Welcome. Thank you, Professor Nicholas, for the opportunity. My name is Renato Costa. I am a PhD candidate here at UQ, and Professor Nicholas Aruni is my supervisor. And he has asked me to talk to you a little bit about John Finnis, particularly his idea of constitutions, what constitutions are. Um, I have been doing my research, my PhD research in the nature of constitutions, what constitutions are for. And I came across the natural law theory and particularly John Finnis' theory of constitutions. And here I just wanted to say a couple of things before we actually go into John Finnis' constitutionalism. That is the title there of this lecture, if we call it like that. So the first thing is that Finnis has never written expressly and specifically about constitutional law as part of his theoretical framework. What I mean is he has written about constitutions, about the content of constitutions, about separation of powers, about constitutional cases, but he has never attempted to do so in a way that he encompassed this aspect, the constitutional law, into his broader philosophy of law. So my attempt today is to try, it's on me to try and try to do that, try to understand his broader framework and understand his idea of constitutions and bring them together. So if there are any mistakes or shortcomings, it's on me, it's not on him. And you should be attributing that to me, not to Finnis. It's probably my fault and my lack of perception, or maybe a different interpretation that I had from his work. And the other thing that I wanted to say is that this is part of my current research. So it's still a work in progress. I have been researching about natural law theory, as I said, and the fact is that Finnis is the leading natural law scholar of our time. So the conclusions I've reached and the things that I'm sharing with you today are part of this ongoing research. There's no, this doesn't represent a final view of Finnish constitutionalism. This is not a final expression of his idea of constitutions. Maybe after, with more research, I will be able to add some things or change other things. But I think nonetheless that the idea of his philosophy and what his understanding of constitutions will be present here. And I hope to be clear and objective in my explanation of it. Um, and finally, the last thing that I wanted to say is that if you turn to the slides there, you will see that my email is there. I had to pre-record the lecture because I am currently traveling, and hopefully I can log into debate and try to answer some questions by the time you're watching this. But just in case I cannot do it, if I am unable to log in, that is my email. You can contact me. I'm more than happy to receive any contact from you and chat about Finnish, about natural law, about constitutionalism. Yeah, virtually anything that you want to talk about related to this. And so feel free to send me an email if you want to. And I just a couple of years ago, I was actually sitting there and listening to Nicholas talks. So I was an LL.M student at the university as well. So I'm more than happy to help you in whatever you need in this journey that you're in. So let's get to it. To start, let me just present you who John Finnis is, because of course we are talking about him, so we should know who he is. And this is a summary of his curriculum. As you can see, and you will see, there's a lot of relevance in he's a very significant academic in a relevant field. So you can see that he is Australian. He is from Adelaide, and he did his LLB at the University of Adelaide, and he finished in 1961, and he went straight to Oxford. He did doctorate there under the supervision of H.L.A. Hart. So Herbert Hart was actually his PhD supervisor, and this is quite interesting because it indicates how Finnis really grasps Hart's theory and assimilates some aspects of it in his own philosophy of law. Um, you can also see there that he lectured um, at the University of Oxford for a long time, since the end of his doctorate. He became an emeritus professor in 2010, and by that time he was already teaching other universities as well all around the world. So we have examples there. He taught at University of California, Berkeley, University of Malawi, Boston College Law School, and particularly the University of Notre Dame in the US as well. And just last year, the end of last year, he announced that he was going to retire from that university. So he's to be retired. I think he has already retired. I put that he will be retiring 2021. I'm pretty sure he has already done that. And just to show you once more that he is a very important person, a very important academic and scholar, a scholar of influence, you can see that he has received the Queen's Counsel honor, and he has the Companion of the Order of Australia as well. So two titles that are very important and reveal his importance as well for natural law theory, for the academic world, and even for political areas as well. So he is, as I have said, the leading figure in the natural law theory today. He has been considered by some as the most important philosopher of law of the century. Some say that his writings will be the object of study for the next century or so. So, yeah, um, you can see how important it is to at least understand some aspects of his theory. So, let's dig into his philosophy a little bit more. Um, The first thing is that I wanted to say there is that the picture is not of Finnis, it's of Thomas Aquinas. And the reason for it is because Finnis draws a lot of his thought and philosophy from Thomas Aquinas. In fact, he has written a book called Aquinas, Moral, Political, and Legal Theory. And in certain parts of that book, it is hard to know if Finnis is really talking about Aquinas or himself, because their philosophies intersect a lot. So, in many moments during the lecture, you will see me referring to Aquinas, which is the same as saying that Finnis has the same position, the same stance as Aquinas in that topic. Um, just another caveat there. Finnis is deemed to represent the classical natural law theory, but he's not fond of the term. He thinks that there are many different theories in natural law. And even the classical natural law has different exponents, like Plato and Aristotle. They have actually different theories. So, in this point, it is relevant to say that Finnis, like Aquinas, is much more Aristotelian. So, he follows Aristotle more than he does Plato. Um, and because Finnis follows a lot of what Aquinas has said, he ended up citing and developing much of the Aristotelian thought. And finally, the last remark I want to make before we really start with his theory and philosophy is that we are referring here to the natural theory of law. And this is a limitation, a qualification of this aspect of the natural law theory. Because the natural law theory has multiple interdisciplinary implications. We are obviously focusing on the law side of natural law tradition, but Finnis writes about natural law in other senses. He writes about it in ethics, in theology. So, um, however, he being a professor of law, at least an emeritus professor now, he has developed very clearly his natural law philosophy of law. So the natural law theory of law is a part of the broader natural law tradition, and constitutionalism is one of the elements in the natural law theory of law. That's why we will try to dig into um, this aspect. But before doing that, we have to explain some of the broader, um, some of his theoretical framework. But of course, we'll be focusing on his theory of law. Um, the first thing, and maybe the most important thing that we ought to take from this lecture, is that for Finnis, law is both a sheer fact and a reason for action. It is a fact in the sense that it exists materially. Not that law is something that we can touch, but it's definitely something that we can see, we take to express a state of affairs. It is a sheer fact, it exists. I think this aspect is pretty straightforward. Laws exist, they coerce, they direct, they are born, they die, they can be imposed or promulgated, and they express such facts as social institutions and political institutions and social situations, etc. So the other sense of law is that there are also reasons for action. So this is the distinctive aspect of the natural law tradition um, concerning law. Not only laws exist as positive enactments, as fact, they work as normative, reasonable justifications of conduct. They direct acts towards something, towards a goal, a point, an end, an objective. They are dictates of reason, as Aquinas put it. They prescribe normatively, morally, what one ought to do, to have, to achieve, to fulfill. So the first aspect of Finnis' theory of law is that he does not see a dichotomy, a conflict between positivism and natural law. Because even before the first positivists like Bentham and Austin were born, Aquinas had already recognized that law is positive, that laws have this positive sense. Laws need to be enacted, they need to be valid. The political community ought to recognize the validity of the law for it to be binding and effective. Law has a positive, a factual side. The only difference, therefore, is that in the natural law tradition, law is not exclusively a fact. It doesn't just have the factual component, but also a normative and moral component. So take that sentence there. Um, Unjust laws are not laws at all. This is something that Augustine had said, which later on was popularized by Aquinas, and Hart mentioned in his writings as well. Unjust laws are not laws at all. You know, Hart took that phrase and criticized it. He said that unjust laws can also be laws. But Finnis argues that Hart misses the point here. Um, he doesn't fully understand the meaning of that phrase because, as the phrase goes, Finnis says, indeed, unjust laws can and are still laws. Finnis then dissects that saying and comes to a different conclusion than that of Hart. Take a look at it. Unjust laws are not laws at all. This is a statement that integrates both components of what the classical natural law theory of law understands of law. Um, it is a statement that integrates the factual and the reason for action side. It affirms that unjust laws are still laws. They are laws, at least in the factual sense. Otherwise, that first part of the sentence would be meaningless. Unjust laws are laws. but they lack that moral obligation. They have no moral or normative authority because of their injustice. Since these laws are unjust because they are a perversion of law, because they are not fulfilling that which laws are meant to fulfill, they are not morally obligatory. It is the same thing as saying that an untrustworthy friend is not a friend, or um, that a car with a broken engine is no car at all. You see that? This is the idea of the phrase. This is the relationship established here. If the law is incapable of fulfilling its normative elements, it is a law only in the factual sense. It does not compel one morally. What Aquinas says, and Finnis takes pains to explain, is that the law has two sides. And if we acknowledge the law has both a factual and a normative side, then the point of legal positivism is really not worth pursuing. Because natural law does not contradict legal positivism, it encompasses it. Legal positivism, and Finnis has already said that expressly, legal positivism is a creation of the natural law theory, of the natural law tradition. So I hope you're following the argument. But let's move on, because we do understand that law is a fact and a reason for action. But in the natural law tradition, this is further explained by Aquinas and Finnis in the idea of human laws. And I think Professor Nicholas has already explained in your previous class that Aquinas divided law into four categories. This is part of his treatise of laws in the Summa Theologia. There is the eternal law, the natural law, the human law, and the divine law. The eternal and the divine laws are not important here right now for us, so we will forget about them for a moment. So let's focus only on the natural law and the human law. The natural law, Aquinas says, is the participation of our reason in God's eternal law. In very basic terms, and please allow me to be oversimplistic here, the natural law is the way in which our reason is directed towards pursuing goods and avoiding evil. So natural law is, again, in basic terms and superficially speaking, the work of our reason towards accomplishing coherent, harmonious, good objectives, ends. So the human laws are the expression of such reasonableness towards what he calls the basic goods. They are dictates of reason for action, and they can be made in either one of the following ways. Two ways. Either by determination or conclusions, deductions, or entailments. Is that clear? So we have the natural law, which is our natural reason participating in something that is eternal in God's law, God's eternal laws, that is, our sense, our reason pursuing goods and avoiding evils, accomplishing our reason directing us towards something to accomplish something that is called the good, an ultimate end, or ends, more specifically saying. And we have human laws, they are the expression of this reasonableness. So they are the result of this natural law, and they exist in two ways. They can be posited in two ways. One of the ways is by determinatio, and this is determination. This is what Aquinas calls this first way, and the other one would be through conclusions, conclusiones, deductions, entailments from natural law. So let me explain each one of these. Conclusions are the entailments of natural law. So, for example, natural law, a reason towards what is good to be pursued, would say that killing is wrong. And indeed, this is the content of many laws around the world. In ancient times, these were called the jus cogens erga omni, which is the compelling rules for all humans. In Article 38, Paragraph 1 of the 1946 Statute of the International Court of Justice, this is called the General Principles of Law. Aquinas called it the conclusiones of the natural law. So they are deductions, direct entailments of what natural law, a reason prescribes towards doing good and pursuing the good. But there's still the other way, which is making human laws through determinatio. This is still the result of our general reasonableness towards achieving societal goods, but they are not direct implications, conclusions from natural law. They are choices that specific legislators make to achieve certain ends. Positive laws made by determinatio are still derived from natural law, but they are not directly derived from natural law. They are only so indirectly. The laws that result from the process of determinatio still need to be reasonable, but they are not direct deductions. These positive laws give determinacy to unchanging principles of natural law. For example, and this is the example that you see everywhere, it is important to have, for society, to have a coherent system of traffic. Driving on the same side of the road seems like a good rule to preserve human life, social order, and harmony, and all of that relates to principles of natural law. So in Australia, we drive on the left side, but in Brazil, I used to ride on the right side of the road. Um, so am I to come down under and say that Brazil is right and Australia is wrong because the laws here are unjust when it comes to which side of the road I am to drive? No, of course not. So let me give you an example that Finnis uses. It is a good for society to have hospitals, to take care of people's illness, to preserve life, generally speaking. So we ought to build hospitals. But the design of the hospital is really up to the designer. If the door of the hospital should have 2 meters or 2.5 meters is really not a big deal. If there will be 200 parking spots or 150 is a choice for the person building the hospital, right? So the same happens with laws. Human laws differ in certain aspects, but they are fundamentally meant to achieve something. So, in my understanding of it, it doesn't really matter if a constitution says that elections will be held every 3 years or every 5 years, if the state is unitary or federal, if there is a strict separation of powers or not. This is something that the legislator will decide among possible choices and options, all of which, it is assumed, are reasonable and will achieve a certain good. I think this also reinforces the argument against positivism trying to oppose the natural law theory of law. There are aspects of our constitution that are indeed the result of pure determination. That is, they are a fact, a choice of the Constitutional Assembly, the framers, to put that specific provision in that constitution. So it is entirely consistent to study the specifics of a constitution, its provisions. That's fine. It does not contradict natural law. In fact, the provisions are still derived ultimately from natural law. But it becomes, however, the study of one of the sides of what constitutions are. It focuses on the creative side of constitution making, the positive side, or as Aquinas himself called it, the positive jura. actually he said positiva jura. But furthermore, as I have said, there are other parts that work as mere conclusions from our reason, from the natural law. Like, I can think of the example of non-discrimination against other people because of religion, color, sex, place of birth, accent. Okay, maybe not accent, but still, this is a good example of entrenched constitutional conclusions from natural law. So both sides of what law is are present here and are present in this making of laws. The factual and the psychological, the determination and the conclusion, the positive and the normative. Do you see that? So it all comes back to that understanding of law as both fact and reason for action. But let's move forward. You might have realized that Finnis and Aquinas have a teleological epistemology. That is, like Aristotle, they identify the nature of a thing by asking what are that thing's ends, objectives, point. So to talk about laws, it doesn't really matter the content of the determination, of the determinatio, as long as the law is fulfilling its purpose of directing people towards the common good. Aquinas said that the purpose of human laws is the temporal tranquility of the state. Specifically to constitutions, then, it seems to me that it ought to direct the political community to the public good, to justice and peace. The way in which the constitutional legislator chooses to do so doesn't seem to bother Finnis. As long as the constitution works to lead people to justice and peace, it's fine. Because in his epistemology, it's not about the specific content, what the determination was, but rather its synchrony with the normative side. The fact that the conclusions, the determinatio, the laws, the constitution, the provisions of the constitutions, they are working towards the good, the end of society, which specifically here relates to justice and peace. And this will become clearer later on. But this teleological approach reveals another aspect of Finnis' philosophy. He calls it the central and peripheral cases. Central cases for Finnis are the proper, the full, the genuine definition of a thing. It is the primary example of the object one aims describing, while the peripheral cases are the deviation, the watered down, the corrupted versions of that central case. So Aristotle used to call it the focal meaning, and Aquinas called it the thing simpliciter, meaning unqualified. You didn't have to put any other qualification in that because that is what the thing is. And this is where Finnis takes his idea of central case. So thinking about law and using that teleological method, Finnis says that laws are for the common good of the community. If a constitution, let's say, does not aim at achieving the common good, if it is favoring a specific faction or a party, if it is unjustly taking sides, then it cannot be a central case of constitutions. It is not a constitution at all. Did you hear what I just said? If a constitution does not aim at fulfilling the public good, the justice and peace of that community, then it is not a constitution at all. Basically, what am I saying? That although that constitution exists in the factual world, it is, let's assume, it is a written constitution. So assuming it is a positive enactment of parliament, although that is a fact, it is not a central case of constitutions. It is not a constitution at all. Why? Because it lacks moral obligatoriness. It is a peripheral case. It is a corrupted version, a deviation of a central case constitutions. because it is not aiming to achieve the proper goals of constitutions. Constitutions exist for the common good. This is the central case. This is their aim. So if a particular constitution deviates from that aim, then it is not a central case constitution. It is a perversion of a constitution. If unjust laws are not laws at all, constitutions that do not direct its society to their political common good, it is not a constitution at all. I hope this was a sufficient explanation of some aspects of Finnis' theory of law, and I have tried to draw some implications of it to the realm of constitutionalism. So allow me to finish with a more focused account of what I believe a central case constitution looks like in Finnish terms. Let me start by saying that there are two concepts that, apart from what we have already said, I believe constitute the basis of Finnish idea of constitutions. The first is that of political community, and the second, the public good. So, political community, as you see there, and you can see Finnish quote there, it exists because of the nature of human beings. We are sociable, naturally associative individuals. Even if you are the shyest or the most introvert person, you are born into society and you need society. You need people to develop, to learn, to grow. You need people around you. Particularly for our area of focus here about constitutions, Finnish defines them as the part of a political community in a particular territory. So we live in states, and these states have their national territories, and constitutions exist in that context. Now, okay, before you ask, let me just say that I don't think Finnish is saying that constitutions only exist in the context of the national states. That does not seem to be the case, especially because he has advised countries and states in federations about their own constitutions. And in fact, he has even advised Queensland when the Australia Act appeared. So I don't think that's the case here. So more than reading this as saying that only national states have constitutions, I think we should read it as national states have national constitutions. You see that he says that there? When he refers to the national legal system, he says a national constitution in a defined territory. So he's not restricting the possibility of constitutions exclusively to national states. But is it possible to fit his philosophical framework and eventually think of a global constitution? I'm not sure. I particularly don't think his philosophy fits with this idea of a global universal constitution, but I don't think it relates to this aspect of the political community. I think it is something that the second aspect, the aspect of the public good, prevents from happening. So let's move forward. As I summarized there, he refers to constitutional law as the framing and structuring of a polity to accomplish the common good. Of course, as I said, the Constitution finds its identity in the identity of the community it belongs to structure and to frame it. But that is not all. Remember that a central case will have a goal, an end, a reasonable objective. So constitutions exist to promote the common good. But what does he mean by common good? Particularly here in this situation of constitutions, which is our focus now, finis means the political common good, or as Aquinas calls it, the public good. So look at the quote there. To say that a community has a common good is simply to say that that communication and cooperation has a point, which the members more or less concur in understanding, valuing, and pursuing. So the common good that a particular society aims to pursue is called the public good. It is, as Aquinas said, the justice and peace, the tranquility of that particular specific community. I hope you can see how everything sort of comes together here. Can you? So constitutions are human laws. Constitutions are facts and reasons for action in a community. They direct the community towards its point, its ends. Constitutions exist to frame and structure that community's cooperation, communication, harmony, friendship by giving that people reasons for action as dictates of reason. And because of that, the specific content of constitutions is not particularly relevant for the central case, except if it does not direct to the common good. Constitutions accept different determinations, but they ought to direct society to their common good. And the specific common good here that constitutions ought to achieve is the common good of that particular society, what that community values in justice and peace, their public good. So I hope this was helpful. I hope you managed to knit together all of those pieces of Finnis' philosophy of law into his idea of constitutions. Since you have survived thus far, I thought I would formulate what I think could be a central case of constitutions. But please, I beg you, as I said in the beginning, this is not something that Finnis has said, and it will still need some refinement. Okay? But here it is. Look there. Constitutions, and this is again my own view of it, okay? Constitutions are the factual and normative sets of rules that frame and structure a specific society's unity and identity in orders with reasonable legal, political, and moral justification that political community's public life in such a particular way to achieve their instrumental political common good of justice and peace. Let me break it down. I underlined it to facilitate. So it's factual and normative because constitutions are obviously laws. And in order to be continuous and integrated in society, and here's the principle of continuity in Finnish thought, which I didn't explain, but is there. Constitutions are considered as sets of rules, and they frame and structure the political institutions, the legal principles, etc. So, another aspect is that they exist for specific societies. They are intrinsically intertwined with the political communities that created them. They are reasonable as justifications for action. Otherwise, they would be unjust. And if they are unjust, they're not a central case because they would be only factual but have no reason, no practical reasonableness in providing direction for action. They refer to specific societies, as I have said, and central case constitutions have a point, an objective. And that objective is that particular community's political common good, what Aquinas called the public good, and specifically it represents justice and peace. So this is what I believe is the central case of constitutions in Finnish thought. I hope you enjoyed it. I hope you liked the lecture. I hope I was clear and objective. As I said, there's a lot more on Finnis in his theory of law, and it would take a lot of time, and we would have to be really specific in dealing with each aspect of his philosophy. But as means of an introduction and as a way of picturing how Finnis, I think his broader philosophy fits in and finds its way in our own study of constitutions. I think this was enough, and I hope it was enough. I hope you enjoyed it. I hope you could understand it. And I wish you all the best in the rest of the class and the course. And as I said, my email is up there. If you want to contact me, I'm more than happy to answer your emails. And yeah, thank you for listening. Have a good one. Bye.